Okay, you can now relax. All is well that ends well. I want to congratulate both teams for an excellent performance, really. Both of you have really put up a spirited fight. The arguments were good. Presentation, preparation and familiarity of the facts was good. Structure of legal argument was good. Knowledge and application of the law was good, although one team performed better, as you later know. Organization and presentation, speaking ability, excellent. Responsiveness to questions, good. Courtroom etiquette, good. Only that next time when they introduce you, counsel Alupo, when co-counsel introduces you, you don't remain seated. He introduces you, he sits down, you stand up, then he stands up again, just like she did. So that's the only observation I made on your part. Mokabire Moses, you were good, you know, you were good, only that I think you have to be a little bit slower. You are not running when you are talking. You have your facts, you have your law, but you can be a little bit slower because you assume that the judge is writing. The judge is not a machine that records, that you put the recorder and then you are, so you take it easy, and that's how Sunday beat you, because you could see that he wasn't so fast, and at the same time he concentrated more on the application of the law to the facts. He would really bring out what has been done, what has not been done, and what is the bare minimum that the law requires, what has been done, what has not been done, and why it has not been done. So you find that in his presentation, he was more persuasive. Sometimes court cases are one like that. You can really have an average, you know, it's a 50-50 case, but then the persuasiveness, even his tone, you know, you would see that he brings out the argument more clearly, and yet it's not very detailed, but very precise, but also very relevant. You get? So that would mean, Moses, if you could a little concentrate more on summarizing those arguments without losing the relevance, you can do better in the next in the next round. Then also learn to balance. It's not only you, because that you don't have to be self, you have to level, do 15 minutes, and let your colleague also do 15 minutes. And now that points out why you were not able to summarize your arguments, because they were very detailed, and yet here sometimes you go to a judge and they say, my lord, I have 4 issues, I'm going to argue issue 1, 2, 3, and then says, no, I see issue 1 is related to issue 2, so just address me on issue 2. And now once you have that, and you are not that type that is very precise, you're already off, because in your head you've crammed the flow. But Sharif, I'm sure if he was just told to speak off head, you would tell that he has mastered his facts very well and can play around with the facts. Because what the judges will be looking out for, what is the problem? What does the law say? what has been done, what has not been done. Alupo, you concentrate more on the law. These judges know the law. They actually read the law from law school, LDC. They will just appreciate that you know the law, but they are more interested in analysis. They are more interested in analysis, you bringing out the real issue. You know, I told you that trial is about evidence. It's not about the law. Don't stop quoting the law. That is important. But in my view, I would rather you concentrate more on bringing out the issue at hand, just like Sharif was doing it, without, of course, losing the law, because the law will guide you. What are the minimum standards? You mention them. You tell us whether those minimum standards have been met or not. If not, why? That's what they were doing. That's why they were kind of better, because they discussed it in that context. Whereas for you, you were, you were, yes, you knew the facts, you knew the law, but you didn't argue it in that context. What is the minimum? What has not, for you, because you are supposed to concentrate on what is the minimum and what has not been done, and what do you want to see happen. Are you getting me? What do you want to see happen? So Sandy, I think I've already made my comments. I think you just have to continue like that. Moses, I've told you. Alupa, I've also told you. Don't over-concentrate on the law. That's why I told you, what is the violation? You still took me to the law. Yet I wanted to hear the facts. What has been violated? What are those violations that you're talking about in the facts, not the law? Because you had already outlined the law. You get? Gloria, I think you have to just continue. Look at what Sharif is doing and also perfect. Okay? Yes, you know the facts, but you can still borrow more things from him, so that you don't look very far apart from each other, yet it is one team. I would assume that both of you should be at the same level. So this is how you scored. Mukabire Moses, I'll first read the individual performance, okay? Mukabire Moses, overall 90. Alupo Lydia, overall 74. Sande Sharif, overall 94. Nasije Gloria, overall 88. So you can see that it was like a final. I don't know about the other teams, but for me, I was impressed by both teams. But you know, there's always a winner, and there's always one who follows after the what? After the winner. So team average, applicants 82. Team average respondents 91. So if you can improve on those few observations, I believe I will see again in the would they be semi-finals? Semi-finals. I hope to see. Don't disappoint me. Fight that you come back. I don't think those guys can beat you. If you can only address those what? In any case, they are not hearing. If you can only address those areas, you should be able to come back in the semi-finals. And now you can share so that you come back in the semi-finals. Good luck.
Welcome back from the first preliminary round. We are waiting for just 2 more courts which are finalizing somewhere downstairs. And then please, we have pinned the schedule for the second preliminary round. So you should check out and try to locate your room and find it in that time. Once they are here, we are going to start immediately. Yeah. So find out where you're going to sit in the second round. CLMG, if CLMG is here, prepare to proceed ex parte. If you're done, please check out your room and you can settle in your next room. Dear Mooters, I would rather that you find your courtroom and prepare from there, because the next session here is going to be starting shortly. And if you're due to present from this courtroom, please take your seats already and settle in from there. We wish you the best in your second round. You have a chance to argue for the other side of the case. You have a chance to right your wrongs. You have a chance to redeem your marks, and by the end of the second preliminary round, you'll find out some of your preliminary results. All the best in the next round. just in front here. You know it? Your font, please. Someone's font. CLMA. CLMA was in here. CLMA. Who is she? Who are you saying she? Okay, you be in the court. Let me follow her up. On the team as well. I think the team is making their way. No. Okay, so we've just pinned the chat here. Kindly cross-check and find out your room. Which team are you? CLMJ, you're presenting from here. You're welcome. Is Team CLMA still here?
Good afternoon. Good afternoon. I can't hear the lawyers here. They are the ones I'm interested in. You are reminded that you are in court, so you maintain court decorum. I welcome you all to this afternoon session. This is how we are going to proceed. My name is Timothy Lumunye, the presiding judge in this case. So we have two teams. One team, I believe these are the applicants and you are the respondents. The applicants will submit first and then the respondents will respond. My only guidance is that since each of you has 30 minutes, I request that you share 15 minutes, because at the end of the day you will be assessed individually, and then after that we shall get the team average. So mind time when you are making your submissions. So allow me to write down your details and then I will alert you when to proceed. Who are the applicants? Team J? You're the applicant. Okay. The title is His Lordship. Now you are appearing in the High Court. So you're going to submit in this order. Ojambo Festo, you submit first. Tubuite Grace, is that the way you had arranged? Chigozi Herbert, you submit first. And then Tumwesi J, you will submit last. Good luck and please try to keep time. Can proceed.
during the grab of the MOOT festival in the Federal Republic of Mozambique, characterized by loss of life of a young girl in the circumstances, and also increase in pregnancy rates among the citizens of the Federal Republic of Mozambique. And my lord, this was due to the regard that the state was negligent in the circumstances in failure to honor its obligation as established under the laws, in particular the Constitution and the enabling international instruments in the circumstances. And it is on this premise that the applicants have before this honorable court seeking the orders as we shall be present in our case before court. The lordship, the applicants proceed to address this court on jurisdiction. The lordship, according to Article 15 of the Constitution of the Republic of Mozambique, this honorable court is vested with jurisdiction because under Article 15 clause 2 it provides that if any person's rights have been violated, any person or organization can come up and bring a suit on behalf of those persons whose rights have been violated in the circumstances. And it is on this premise that we are before this honorable court, and also in pursuant to Section 4 of the Human Rights Enforcement Act, it also empowers this court and vests it with jurisdiction to hear our matter. And your lordship, according to the case of Legal Brain Trust Limited versus the Attorney General, with seniors application number 314 of 2021, Justice Mr. Sekana held that the High Court shall be vested with jurisdiction to hear matters of human rights violation, even if it is instituted by any other person on behalf of others, as long as they are personal and individual rights. And my lord, it is on this premise that the applicants do submit that this honorable court is vested with the jurisdiction to handle this matter. And my lord, I now proceed to issue 3. And issue 3, the applicants are going to show, firstly, to this honorable court, that the state had an obligation to provide essential training and information on sexuality and healthy reproductive rights of the citizens of the Republic of Mozambique. And secondly, that the state violated or failed to honor its obligation in the circumstances. And your lordship, according to Article 20 of the Constitution of the Republic of Mozambique, it provides that the state has an obligation to uphold and make sure that the rights of the citizens are upheld and they are not violated by any authority or by any person in the circumstances. And your lordship, pursuant to Article 32 of the same Constitution of the Republic of Mozambique, it provides for affirmative action whereby the rights of the marginalized groups in the circumstances shall be uplifted and upheld by the state. And your lordship, according to Section 5 of the pre-primary, primary, and post-primary, post-primary, and primary Act of 2008, it mandates, under Section 5, it mandates the state to go ahead and enact or come up with the policies on essentially providing trainings on various matters in the state. And in this instance, the applicants do submit that in that response, under Section 5 of the Act, that's the pre-primary, primary, post-primary, post-primary, and primary Act 2008, the state, under Section 5, has an obligation to ensure that health and reproductive rights of the citizens are upheld in the circumstances. And your lordship, according to the case of Sehad and others versus Executive Director, Mulago Hospital, civil suit number 212 of 2013, it was held that the state, among the tripartite duties of the state, is to ensure that the health rights of the citizens are upheld. And to this end, it is the applicant's submission that among the upholding of the right to health, the state has to provide essential training and information in regards to sexuality and reproductive health rights of the citizens. And, Your Lordship, according to the case of Sehad versus the Attorney General and Family Life Network, the Senior Code of number 309 of 2016, it was held that the failure of the state to pass a policy on sexuality education and information was a violation of the state's duty to ensure that the rights of health of the citizens are upheld. And to this end, according to the judgment of this case of Family Life Network, the state has to ensure that essential training are provided in the circumstances. And, Your Lordship, according to paragraph 10 of the fact, it is provided for that SOHAD had brought up an initiative to provide essential training to the citizens in the circumstances to ensure that they receive information on sexual and reproductive health rights. But, Your Lordship, our discipline, the state went ahead and impeded or sabotaged this arrangement by SOHAD, an organization in the Federal Republic of Ossetia. And according to paragraph 8 of the facts, a report was given out by SOHAD showing that 70% of the young people in the Republic of Ossetia always were succumbed to pregnancies during the Grab the Meat Festival. And to this end, this was a failure or a violation of the right to health of the citizens of the Republic of Ossetia, whereby the state failed under its obligations to ensure that essential training is provided to these young children in the circumstances such that they could be aware of the likely effects of engaging into such activities, which also involved virgin girls moving with naked with and Lordship, according to that sabotage those events and anatomy which encompasses the right to health of the citizens of the Republic of Ossetia. Much obliged. Your Lord, do submit that the failure of the state to ensure that training and information is provided violation of the constitutional rights of the citizens and also against the party. Issue 4, the applicant's first an enabling clause was a violation, and second, that the state failed to honor its obligation. It was held as to thoroughly and intelligently, and it is our submission that this court finds the case persuasive in the circumstances, held that if the state has to go on and conduct investigations, in the premise that the state has initiated the same, but has not conclusively conducted the investigations, the state has to come out and inform or give the reasons before court as to why the investigations are being impeded or as to why there is delay. But it is our submission that there was nothing to that effect, and which shows a deliberate attempt on the respondents not to their obligations as mandated under the relevant laws. And in conclusion, it is our humble submission as applicants that the state failed
the state's failure to investigate and bring to book the culprits or violators of the constitutional rights of the citizens of the Republic of City was a violation of the constitutional rights of the citizens in regards to sexual and reproductive health rights. I so submit.
Okay, thank you, Council Jambo Festo. Let's listen to co-counsel.
Issue 1 concerns whether the failure of the state to provide information through age-appropriate sexuality education was a violation of the constitutional rights of the citizens of jurisdiction. And my lords, in addressing issue 1, the applicants will firstly show this honorable court that firstly, the state had the obligation under the provided laws of the Republic of Jurisdiction to provide information through age-appropriate sexuality education. And secondly, that the state failed to fulfill this obligation by not providing information on sexuality education. And my lord, your lordship, issue 2 concerns the failure of the state to pass a policy on sexual and reproductive health and rights to protect the vulnerable groups of the city from harmful cultural acts and practices. And your lordship, in addressing issue 2, the applicants firstly show this honorable court that the respondent state had the obligation under the provided laws of the city to pass a policy on sexual and reproductive health and rights, and secondly, that the state failed to fulfill its obligation by not passing a policy on sexual and reproductive health and rights. Your lordship, I shall now turn submissions. Your lordship, it is the applicant's position in regard to issue 1 that the failure of the state to provide information through age-appropriate sexuality education was indeed a violation of the constitutional rights of the citizens of Unsiche, most especially the young people, as well as the international obligations in regards to the applicable law. Your lordship, according to Article 30 of the Constitution of the Federal Republic of Unsiche, provides for the right to education of every citizen. And your lordship, it is upon the state to take or enforce appropriate measures to ensure that every citizen of the state receives or attains equal opportunity to attain the highest standard of education. Furthermore, your lordship, Article 41 of the Constitution of the Federal Republic of Unsiche provides for the right to access of information. Your lordship, it is upon this right that the citizens of the Republic of Unsiche are able to make informed decisions based on correct data. Furthermore, your lordship, I pray that this honorable court is persuaded by the case of Center for Health, Human Rights and Development and 2 others versus the Executive Director of Mulago Hospital and another, civil suit number 212 of 2013, where Justice Mugambe held that it is upon the state, or the state has tripartite duties, firstly to provide or to protect, ensure and promote the right of health of its nationals. And my lord, and your lordship, it is upon this that the state has the obligation to provide information including sexuality education. Additionally, your lordship, Article 1.1 of the International Technical Guidance on Sexuality Education highlights the need for the state to provide age-appropriate, updated, as well as accurate information on sexuality education. And as a result, this helps in curbing high instances of teenage pregnancies as well as sexually transmitted infections. Your lordship, according to the facts of the case at hand, the state did not only fail to provide information on sexuality education, but went ahead to pay a deaf ear to the recommendations that were made by the leader of SOHAD, Dr. Nora, according to paragraph 11 of the facts, where she suggested for a curriculum review to provide the relevant age-appropriate sexuality education to the young masses. And as a result, it was evidenced, according to paragraph 5 of the facts, that this escalated high instances of sexual violence as well as teenage pregnancies, according to the report that was made by SOHADI in paragraph 5. Your Lordship, in conclusion, it is the applicant's submission that the failure of the state to provide information through age-appropriate sexuality education violated the constitutional rights of the citizens of the Republic of Unsicho, most especially the young people, as well as the international obligations of the state under the applicable law. Your Lordship, issue 2 provides whether the failure of the state to pass a policy on sexual and reproductive health and rights to protect the masses from harmful cultural myths and practices was a violation of the human rights of the citizens of Unsiche, as provided in the Constitution and the applicable law. And Your Lordship, it is the applicant's position that indeed it was a violation, the failure of the state to pass a policy on sexual and reproductive health and rights indeed violated the constitutional rights of the citizens of the Federal Republic of Unsiche. Your Lordship, although Article 37 of the Constitution of Unsiche provides for the right of every citizen as applicable to profess, enjoy, and promote any culture as well as any cultural institution in community with others, it is, however, subject to Article 2, Clause 2 of the Constitution of Unsiche that provides that any custom or culture that is inconsistent with the provisions of the Constitution stands or is regarded null and void. Your Lordship, furthermore, according to Article 32, Clause 2...
So in relation to that submission, what are those cultures that are enforced by the court from the reading of Article 2?
Cultural practices that are enforced by court are those that do not undermine the dignity as well as the welfare of the women and marginalized groups. Much obliged, Your Lordship. Article 32, Clause 2 of the Constitution of Unsiche prohibits customs, cultures that undermine the dignity as well as the welfare of the women and marginalized groups as well as the marginalized groups. And it is upon that according to Article 21, Clause 4A, that the state is mandated through the legislature to implement policies that address social as well as cultural imbalances in society. Your Lordship, furthermore, Article 5 of the Protocol